Good day, everyone. In this video, we're going to discuss the Chapter 4 of the Law on Sales, focusing on the obligations of the vendor. Without further ado, let's start. Section 1. General Provisions. So under Article 1495, the vendor has 5 principal obligations. First is to transfer ownership. The seller must pass ownership to the buyer, even if he was not yet the owner at the time of perfection, as long as he can transfer it at the time of delivery. If the seller claims, for example, that the goods are already in transit but fails to deliver, that becomes a breach of warranty, so the buyer may refuse to pay or recover the price with interest. Second is to deliver the goods sold. Delivery is also called tradition. It should include the accessions and accessories, and it must be in the same condition at the time of the contract. Delivery is required, except during the redemption period in execution sales. Third is the warrant the thing sold against eviction and hidden defects. Fourth is to preserve the thing with proper diligence before delivery, and last but not least is to pay for the expenses of the deed of sale, unless otherwise agreed. So under Article 1496, ownership is transferred not by mere agreement, but upon delivery of the thing sold. So even if there is a valid contract, ownership will only pass once delivery is made. Delivery must also involve the intent of the seller to transfer ownership and the acceptance by the buyer. As a general rule, ownership passes upon delivery. However, the parties may agree that ownership will transfer only upon full payment or upon the fulfillment of the condition. There are 3 ways of delivery. First is actual or real delivery, where the thing is physically handed over. Second is constructive or legal delivery, which includes acts recognized by law as equivalent delivery. And third is any manner that clearly shows the transfer of possession from the seller to the buyer. Section 2. Delivery of the thing sold. Article 1497 talks about actual delivery, which is one of the ways of delivery discussed under Article 1496. Actual delivery happens when the thing is placed under the physical control and possession of the buyer, meaning there is actual handing over of the items, such as handing over a laptop or a cell phone. Once delivery is made, the result loss passes to the buyer even if the price has not yet been paid. However, actual delivery is not always required, since the parties may agree on other forms of delivery. So under Article 1498, it talks about constructive delivery, which is another way of delivery discussed under Article 1496. Unlike actual delivery, this does not require physical transfer of the thing. Instead, it can happen through the execution of a public instrument, like a notarized deed of sale. It can also be done through symbolic delivery, like handing over the keys to where the movable property is stored. But take note, this is only presumptive delivery. It is not automatic. It will not apply if there is no real intention to deliver or if the buyer cannot actually gain control of the thing because of legal impediment. For example, if there are illegal settlers on the property, then even if there is a deed, the delivery is not considered legally effective. Article 1499 covers constructive delivery of movable property in cases where physical delivery is not needed. There are 2 types. First is the traditional longa maneuver, where delivery is made by agreement. For example, the seller points to the machinery inside the warehouse and says, "That's yours." And from that moment, the buyer already has control. Second is traditional brevi maneuver, where the buyer already has possession of the thing. For example, if you're renting something and then you decide to buy it, there's no need to return it and receive it again. The law simply recognizes that you are now the owner. Next, Article 1500 talks about traditional possessory, which is basically the opposite of traditional brevi maneuver. Here, the seller still keeps possession of the deed, but no longer as the owner, rather in a different capacity. For example, if S sells the property to B, but they agree that S will stay as a tenant, the law already considers the property as delivered to B. Even if S is still physically there, his role has already changed from owner to tenant. So basically, there's no need for an actual transfer and return of possession, because the law treats the delivery as completed based on the agreement of the parties. Article 1501 talks about delivery of incorporeal property. Incorporeal property refers to rights or intangible things which cannot be physically delivered. Since these things cannot be physically transferred, delivery is done through quasi tradition, which means transferring control or rights instead of actual possession. There are 3 forms. First is through the execution of a public instrument, like a notarized document. Second is by delivering the title or document of ownership. And third buyer to exercise the rights of a shareholder, like receiving dividends or voting. So even without physical transfer, once the buyer is already using those rights with the seller's consent, it is considered delivery through quasi tradition. So even without physical transfer, the law still recognizes these acts as valid delivery. And again, the most important thing is the intention of the parties. There must be an intent to deliver and to accept. Otherwise, there is no valid delivery. So, Article 1502 talks about the contract of sale or return and sale or approval. In sale or return, the goods are already delivered to the buyer and ownership also passes upon delivery. But the buyer has an option to return the goods instead of paying the price. On the other hand, in sale or approval, the seller sends the goods to the buyer so they can try or examine them. And it's up to the buyer whether to accept or reject them. Ownership remains with the seller until the buyer accepts the goods. Now, acceptance can happen in three ways. It can be expressed, meaning the buyer clearly agrees. Implied, meaning the buyer does not directly say yes but shows acceptance through actions, like selling or mortgaging the goods. Or by lapse of time when the buyer does not return the goods within the agreed or reasonable period. To better understand, let's take a look at the table on your right, where we compare the two. First, in terms of ownership in sale or return, ownership passes upon delivery, while in sale and approval, ownership remains with the seller until the buyer accepts. Second, as to the type of condition, sale or return is subject to a resolutory condition. This is because ownership begins immediately but may end if the goods are returned. On the other hand, sale and approval is subject to a suspended condition because ownership only begins once the buyer accepts the goods. Third, in terms of risk of loss in sale or return, the risk is on the buyer, while in sale and approval, the risk remains with the seller unless the buyer is at fault. And lastly, as a decision in sale or return, it depends on the buyer's view whether to return the goods or not, while in sale and approval, it depends on the buyer's satisfaction or approval of the goods. Article 1503 talks about reservation of ownership. As a general rule, ownership passes to the buyer upon delivery of the goods to the carrier because delivery to the carrier is considered delivery to the buyer. However, as an exception, the seller may reserve ownership or the right of possession until certain conditions are fulfilled, such as full payment. So why seller do this? The seller reserves ownership mainly for protection. First, as security for payment, to make sure the buyer actually pays. Even if the goods are already shipped, the seller still keeps control through documents like a bill of lading. A bill of lading is a document issued by the carrier that serves as a receipt of goods, a contract of carriage, and a document of title, meaning whoever holds it has the right to claim the goods. Second, to protect against the buyer's insolvency. If the buyer cannot pay, the seller can still recover the goods since ownership has not yet passed. However, even if ownership is reserved, the risk of loss may still pass to the buyer upon delivery to the carrier. Now, there are several ways by which the seller may reserve ownership. First, through the stipulation in the contract, where it is expressly stated that ownership remains with the seller until full payment or fulfillment of conditions. Second, where the bill of lading is deliverable to the seller, which means the seller retains control over the goods even if they are already in transit. In this case, the carrier is the bailey of the seller and will deliver the goods only to the seller or whoever the seller authorizes. Third, where the bill of lading is deliverable to the buyer but is retained by the seller. Here, the buyer cannot obtain the goods without the document, so the seller still controls possession, and the carrier cannot release the goods. Fourth, when the bill of lading is sent together with the bill of exchange or draft. In this case, the buyer must first pay or accept before obtaining the goods. If the buyer dishonors the draft, he must return the bill of lading and does not acquire ownership. Even if he wrongfully keeps it, he still gains no right over the goods. Finally, under the rule of protection of innocent third parties, if the buyer wrongfully obtains the bill of lading without paying and transfer it to a good faith purchaser, that third party may still acquire ownership, especially if the bill of lading is in the buyer's name or endorsed in blank. This is based on the doctrine of equity, where between two innocent parties, the loss is borne by the one who made the situation possible. In this case, the seller. Article 1504. The general rule is res follows ownership. Whoever owns the goods at the time of the loss bears the loss, especially in fortuitous events. However, there are key exceptions. First, once ownership transferred to the buyer, the res also transfers, even if delivery has not yet been made. Second, if the seller remains ownership only as security but has already delivered the goods, the res is already with the buyer. Third, if delivery is delayed due to fault, the party at fault bears the risk. Lastly, even before delivery, if the contract is perfected and the goods are lost without the seller's fault, the risk may already fall on the buyer. This is a special rule that modifies the general principle. Article 1505. The rule is no one can transfer a better title than he has. So if the seller is not the owner, the buyer generally acquires no ownership. Exception exists to protect good faith buyers. If the owner conduct made it appear that the seller had authority, the owner is prevented from denying it. Sales under legal authority like court orders are valid. Purchases made in merchant stores, fairs, or markets are also protected. If the seller has a voidable title not yet cancelled, he can transfer valid ownership, and if the seller later acquires ownership, the earlier the sale becomes valid. Article 1506. A buyer can acquire valid ownership from a seller with a voidable title, provided that the sale happens before the title is annulled, the buyer is in good faith and pays the value, and the buyer has no knowledge of the defect. This rule protects the buyers and places the loss on the party who made the situation possible. Article 1507. A document of a title represents goods, not money. Examples includes bills of lading and warehouse receipt. They serve as a proof of possession, ownership, and contract over the goods. And there are two types. First is negotiable, which are deliverable only to bearer to order. The second one is non-negotiable, which are only deliverable only to a specific person. Article 1508. If a document is payable to the bearer, it can be transferred by simple delivery. If it is payable to order, it must be first endorsed, then delivered. Once endorsed in blank or to a bearer, it becomes transferable again by delivery. Article 1509. Endorsement may be in blank to bearer or to a specific person. If endorsed in blank or to a bearer, delivery is enough to transfer it. If endorsed to a specific person, further transfer requires that person's endorsement. Article 1510. Even if a document is marked as non-negotiable, it may still be treated as negotiable if it is payable to bearer or to order. The label does not automatically remove its negotiable character. Article 1511. A non-negotiable document cannot be negotiated. It can be only transferred by assignment. The transferee only gets the rights of the transferor, no better rights, and endorsement does not add anything. Article 1512. A negotiable document may be transferred by the owner or by someone entrusted with it. If the owner gives possession of the document to another person, that may create apparent authority. So, a buyer in good faith is protected, and the loss will fall onto the owner who trusted the wrong person.
Now, moving on to Article 1518. This article is a provision on transfer of a negotiable document. Here, it states that the buyer will gain the title to the goods that the transfer had, as well as B's direct obligation. So, for example, A transfers his negotiable document to B. Now, B will gain the title to the goods that A has, as well as B's direct obligation without the need of notifying him. Article 1514. This article is a provision to transfer of a non-negotiated document. In this case, the buyer will only get the right against the transferor, as well as the right to notify the bailee and bailie's obligation right after. For example, A transfers his non-negotiated document to B. Now B will only get the right to the title of the goods against the transferor or to A, and he needs to notify the bailee. Notification is needed because his rights may be defeated by attachment of a creditor or a subsequent sale of the document if ever he has not yet notified the bailey. Article 1515 is a provision to transfer without endorsement. Here it states the buyer will only get the right to the title against the seller, as well as the right to compel him for endorsement. It is due that a negotiation will only take effect upon endorsement. So for example, on April 1, A transfers a document to B without endorsement. And on April 5 is only when A endorses B. Only by then will the document be negotiable. Also note that before endorsement, there should be no defect known to the buyer for him to be considered a buyer in good faith. Article 1516 is a provision as to when a transfer may be held liable. Here it says that he may be held liable if the document he is transferring is forged, stolen, the goods are damaged, or the document is under consideration. The law also presumes that endorser warrants past endorsements as genuine. So, if the document is impaired, it is not just the transfer will be liable, but also those assigned and those other endorsers. Let's now go to Article 1517, which is a provision to endorsement of a negotiable document. Here, it states that endorsement only means conveyance of the document to the buyer. The transferor, will be free of any liability caused by the bailey. For example, A endorses B. Now, before B claims the goods to the bailey damaged the goods due to negligence. Here, A will be free from any liability caused by the fault of the bailey. Article 1518 is a provision to validity of a document. As supported by the Warehouse Receipts Law, it states that a document is still considered valid even if it's from fraud, duress, mistake, or breach of duty. However, if it is from theft or loss, it is considered invalid. If a document is acquired through the following, the defect must not be known to a buyer for him to be considered a buyer in good faith. Article 1519 is a provision to goods covered by a negotiable document under the care of the bailey. It states that the document shall be surrendered before the release of the goods. The exception is when the depositor is a thief, the real owner claims the goods or attachment by a creditor. For example, A stole a furniture which he deposits to B. Now, any claim by A's buyer will fail since A is not the real owner of the goods. The real owner of the good will get the right to recover it instead. Article 1520 is a provision for a creditor to reach goods under a negotiable document. Here it states that the creditor may ask for court's injunction to prevent the transfer of the document. The exception is when the buyer is in good faith. For example, despite the court order, A transfers the document to C. So since C is a buyer in good faith, the transfer will be considered effective. Now, the creditor or B may only go against A and not to C. Then, Article 1521 is a provision to place, time, hour, duty of the seller, and delivery of a third person. If the place is agreed on, then it shall be followed. But if no agreement was made, this shall be followed in order. First is usage of trade, seller's place of business, seller's place of residence, or the location of the goods if it is placed elsewhere. Next, for time. If there is an agreed time, then it shall be followed. If no agreement was made, the delivery must be made within a reasonable amount of time. As for the hour of the delivery, it shall be made at the reasonable time given the circumstances. Next, for the delivery of a third person, that third person will act as the bailey of the buyer. And lastly, the buyer is not compelled to make a tender of payment until the seller fulfills his obligation, which is to deliver the goods at a deliverable condition.
Let's begin with Article 1522. Article 1522 states that when the goods delivered are not exactly what was agreed, the buyer has the right to accept or reject them depending on the situation. So this means the buyer is not required to accept incomplete or incorrect delivery. The buyer can decide based on what was actually received. For example, if a school ordered 100 PE uniforms but only 80 were delivered, the school may accept the 80 and pay only for them. If wrong sizes or extra items are included, those may also be rejected. So this shows that the buyer is protected when the delivery does not match the agreement. Now moving on to Article 1523, it states that once the seller gives the goods to a carrier or delivery service, it is already considered delivered to the buyer. However, the seller must still make sure the shipment is properly handled. For example, if gadgets are shipped using poor packaging and arrive damaged, the seller may still be responsible. If insurance is normally needed during shipping, the seller should also inform the buyer. So even after shipment, the seller still has responsibilities during delivery. Next, Article 1524 focuses on payment before delivery. It states that when the seller is not required to deliver the goods if the buyer has not yet paid, unless there is an agreed payment term. So this means the seller can hold the goods until payment is made or secured. For example, if event materials were ordered but payment was not settled, the supplier may refuse to release the items first. So this protects the seller from possible financial loss. Because of that, Article 1525 defines who an unpaid seller is. It states that the seller is considered unpaid if full payment has not been received or if the payment fails. In simple terms, even if the goods are already delivered, the seller is still unpaid if the payment is incomplete or invalid. For example, if payment was made through a check and the check bounced, the seller is still considered unpaid. So this situation gives certain legal rights to the seller. Following that, Article 1526 explains the right of an unpaid seller. It states that an unpaid seller may retain the goods, stop delivery, resell the goods, or cancel the sale under certain conditions. This means the seller still has ways to protect himself from loss. For example, if construction materials are still being shipped and the buyer suddenly becomes insolvent, the seller may stop the delivery before the goods are received. So these rights help protect the seller in risky transactions. Lastly, Article 1527 continues the protection given to unpaid sellers. So it states that the seller may keep the goods until payment is made when there is no credit, the credit period has expired, or the buyer becomes insolvent. This means the seller can legally hold the goods until payment is secured. For example, if a store owner fails to pay within the agreed deadline, the supplier may refuse to release the remaining products. So to conclude, these articles focus on protecting both the buyer and the seller, especially in situations involving incorrect delivery and unpaid transaction. That is all for Articles 1522 to 1527. Thank you.
So this law is about the right of an unpaid seller. So an unpaid seller is someone who sold goods but not yet received full payment. And under this article, if the seller delivers only part of the goods, the seller still keeps the remaining goods while the buyer pays the balance. And this right is called a lien of right of retention. So for example, if a seller sold 100 shares and delivered only 30 shares, the seller may keep the remaining 70 shares until payment is completed. But there is an exception. If the seller delivers part of the goods in a way that shows intention to deliver everything, the seller still may lose the right to keep the rest. So the main purpose of this law is to protect sellers who have not yet been fully paid. So this article discusses when an unpaid seller loses the right of lien. A lien means the seller can keep the goods until the buyer pays. And there are three ways the lien can be lost. So first, when the seller gives the goods to a carrier. And second one is if the buyer authorized agent legally received the goods. And lastly, when the seller voluntarily gives up the lien. So this is called waiver. So in this article also says that if the seller wins a court case for payment, the lien is not automatically lost. So the seller may still keep the goods. Also, in some cases, the lien can return. For example, if the buyer refuses to accept delivered goods, the seller may take them back and recover the lien. So in short, the seller loses lien when possession is transferred or the right is waived. So The article talks about the right of an unpaid seller to stop goods while they are being delivered. This right is called the stoppage in transitu, so it applies when the buyer becomes insolvent. So if the buyer already shipped the goods but the buyer has not yet received them, the seller may stop the delivery. So the seller may recover the possession of the goods. So for example, if laptops were shipped to a buyer who suddenly become bankrupt, the seller may stop the shipments and take back the laptop. So this law protects seller from losing both the goods and the payment. So in short, if the buyer cannot pay and the goods are still on the way, so unpaid seller may stop the delivery. So this article explained when goods are considered in transit. So goods are in transit from the time they are given to keep a carrier until the buyer receives them. If the seller rejects the goods but the carrier still has them, they are still in transit. So transit ends when the buyer receives the goods. So it also ends when the carrier holds the goods on behalf of the buyer. So if only part of the goods is delivered, the rest may still be stopped in the transit. So this rule is important because an unpaid seller can only stop goods during transit. So once transit ends, the seller right to stop the goods is generally lost. So this civil code refers to the right of stoppage in transit too. So it allows an unpaid seller to stop delivery of goods while they are still in transit to the buyer. So the seller may either regain and possession of the goods before they reach the buyer, or the seller may notify the carrier. So the notice must be given in time so the goods can still be intercepted. So the seller also bears the expenses of returning goods in transit. And if negotiable documents title exists, it must be first surrendered and before the stop of the delivery. So this article provides the right of an unpaid seller to resale goods when the buyer fails to pay. So the seller may resale the goods if there is an unreasonable delay in payment. So the resale may be done through public or private sale, but the seller cannot buy the goods himself. So the seller is not always required to notify the original buyer, although notice is advisable. If the goods are resold at a higher price, the original buyer has no right to the profit, and if the goods are resold at a lower price, the seller may recover the loss from the original buyer. So overall, this article protects the unpaid seller while ensuring the resale is done fairly and properly. So this article gives the unpaid seller the right to rescind when the buyer fails to pay. So this is allowed when the contract provides for cancellation. So once rescinded, ownership of the goods returned to the seller, and the seller may also claim damages for losses caused by the buyer's breach, and recession must be clearly shown through acts like taking back the goods. And in summary, this protects the seller by allowing cancellation of the sale for non-payment. So next article provides that an unpaid seller retains the right over goods even if the buyer resales them without full payment. So as a general rule, the buyer cannot transfer a better right than what he has. Thus, so the unpaid seller may still exercise remedies like retentions. However, this is subject to an important exception under the law. And if the goods are covered by negotiable documents of title and transferred to a good faith purchases for value, so that buyer is protected. And in that case, the unpaid seller cannot recover the goods from the innocent holder. So next article states that in a contract of sale, so the seller must deliver goods while the buyer must pay the price. Even if the buyer is given a period to pay, the seller generally must deliver first. However, the seller may refuse deliver if the buyer loses the right of the term. And this happens if the buyer becomes insolvent. And it also applies if the security is damaged. And the seller may also refuse to deliver if the buyer violates the contract. And in summary, this article protects the seller by allowing refusal of delivery when the buyer becomes unreasonable.
Article 1537 states that if a seller was to deliver a thing, it must come with a succession and accessories in the same condition it was when the contract was perfected. Additionally, the rights of to the fruits of the item belongs to the buyer from the moment of perfection. In this case, when the delivery date arises, since this is a real obligation. Under Article 1538, it states here that in case of loss, deterioration, or improvement, it will be governed by the provisions of Article 1189. And in this case, the seller assumes the label debtor. If the vendor was responsible for the item's loss, then they must pay damages. If they are not, then the obligation just simply ends. In the case of deterioration, if the seller was responsible for it, then the buyer has two options: either cancel the contract or accept delivery with the claim of damages. However, if the seller was not responsible for the deterioration of the thing, then the buyer simply bears the loss. In the case of improvements, if it was done naturally, then the buyer bears the benefits. But if it was done at the expense of the seller, then the seller has the rights of those of a usufructuary. The seller is obligated to comply with everything that is within the contract, including the size of the land and the quality. But if there is a concern with the size of the land, more specifically it being lacking, then you have these choices: accept the delivery, reduce the price proportionally, and cancel the contract, provided that 10% of the agreed upon land is lost. But this is only applicable per price per land size. If the poor quality of the land is what you are concerned of, then you have these as your remedies. First is a price reduction. Second is to cancel the contract altogether, provided that the reason is either 10% of the land promised to you is considered poor quality, or the only reason why you perfected this contract is because of the promised land and quality. Again, this is only applicable per price per unit type of lands. If the land was bought per unit size and it offers more than what was agreed upon in the contract, then you have these choices. Either accept the land that you originally bought and the excess, or you reject the excesses and only pay for what you have agreed upon. The components of Article 1539 and Article 1540 is also applicable to judicial sales. These are sales ordered by the court, usually to satisfy a debt or enforce a judgment. If the land was bought by a lump sum, then the price is fixed and cannot be changed regardless if the land you have agreed upon is less or more. However, if the land within the boundaries is not delivered whole, then you can reduce the price proportionally or cancel the contract altogether. If you want to file cancellation under Article 1539 and Article 1542, then it must be done within 6 months from the date of delivery. If a vendor was to sell the same thing to two different people, the ownership of the item would depend on what type of item it is. If it is a movable item or a personal item, the first person to physically take it in good faith acquires it. For items that are immovable, like a real estate, the ownership goes to the first person who registers it. If that does not happen, it goes to the first person that takes possession of it. If neither of those happen, then it goes to the person with the oldest title. This rules aligns with the principle of first in time, stronger in right. That means that when the first buyer is generally favored, then the second buyer can win if they act in good faith. Section 3. Conditions and Warranties. This article begins the topic of conditions and warranties. Basically, if the agreed condition isn't met, the buyer has these two
choices. First, refuse the contract altogether. Second, waive the condition. Basically, they will disregard the conditions and proceed as is. However, if that condition is a requirement of a warranty or considered a warranty, its failure isn't just a misrequirement, it's a breach of contract, meaning that the buyer can sue for damages. In terms of delivery and payment, the payment can be postponed if the buyer has yet to receive the item, since they can treat the seller's duty to deliver the item as a condition that must happen first before the buyer makes their payment.
1546 talks about express warranty. This happens when the seller clearly says something or promises something about their product. And because of that statement that they made, the buyer decides to buy the product that they're selling. The key idea here is the buyer relies on what the seller said about the product. For example, you're buying a phone and the seller tells you this phone has 256 gigabyte storage, and because of that, you decided to buy the phone. But later on, you find out that it's only 64 gigabytes. And even if the seller didn't intend to lie to you, they can still be held liable because that statement that they made became an express warranty. If the seller just says, this is a very good phone, then they're just stating an opinion and it isn't considered as a warranty. Article 1547 talks about implied warranties. So unlike express warranties, these are not stated but automatically exist by law. Even if the contract is silent, the law already assumes certain protections for the buyer. So these are three important notes. First is the warranty of title, meaning the seller actually has the right to sell the item. Second, the warranty of peaceful possession, meaning that no one will disturb you in owning it. Third is the warranty against hidden defects, meaning that there are no hidden problems that were not disclosed. So just imagine that you bought a land, and after a few months, someone suddenly claims that the land is theirs or that the land is mine. If they win in court, that means the seller did not have the right to sell the land in the first place. So they violated the warranty title. So now, these are the important notes, and these are the warranties only apply if first, the sale is valid. Second is that there is no waiver. And lastly, and the buyer didn't know about the problem. Article 1548 talks about warranty in case of eviction. Now, this is a very important concept, since eviction happens when the buyer is legally forced to lose the property either fully or partially, but not just any means. It must be first, based on a final court judgment. Second, it is caused by a prior right or the seller's action. In simpler terms, it means someone had a better right before the sale even happened. For example, you bought a house, and later, a person in court said that they owned it earlier and you lose the house. Now that is eviction. And because of that, the seller becomes responsible even if nothing about eviction was written in the contract. Article 1549. Now under this article, here's something practical that the buyer is not required to appeal to the court's decision. Why? Because the law doesn't want the buyer to waste more time and money just to prove the seller's liability. And it is valid as long as there is already a final judgment and the seller had a chance to defend themselves. Article 1550 talks about the adverse possession. This one can be confusing, so focus on this idea that the timing is everything. So if someone gains ownership because they've been occupying the property for a long time, then if that ownership was already complete before the sale, then the seller is liable. But if it becomes complete after the sale, then the seller is not liable. Why? Because after the sale, the buyer already had a chance to protect their property. Article 1551 talks about the non-payment of taxes. So this is very practical. And if the property is lost because of unpaid taxes and the seller did not inform the buyer, the seller is still liable. For example, you bought a land, but you're not aware that it had unpaid real property taxes, and later the government auctioned it, and you lose the land. So it means that it's just so unfair to the buyer. So the law protects the buyer by making the seller responsible for the issue of it. Article 1552 talks about judicial sales. This applies when property is sold through a court process. And here's the key point. The original owner or the judgment debtor is liable and not the sheriff. Why? Because the sheriff is just doing their job and they don't guarantee ownership. So if there's a problem later, the responsibility goes back to the original owner. Article 1553 states that any agreement removing the seller's liability is void if the seller acted in bad faith. So bad faith means the seller knew about the defect but did not disclose it. For example, if the seller knew the property and ownership issues but still sold it, they cannot escape liability even with a waiver. Article 1554 talks about the waiver of eviction. So this is when the buyer gives up their right to protection, and there are two types of it. First is consent, where the buyer knows that there is a risk but still proceeds. And the second is intentionality, where the buyer merely accepts all the consequences. Now here's the rule of the waiver of eviction. If the buyer did not fully understand the risk, then the seller is still partially liable. But if the buyer fully understood and accepted it, the seller is generally not liable.
Article 155 explains the rights of the buyer or vendee when eviction happens. Evictions means that the buyer loses its property because another person has a better legal right over it. When eviction occurs, the buyer may demand remedy or compensation from the seller or vendee. Article 1556 discusses partial eviction if only part of the property sold lost because another person has a better legal right. The buyer may rescind or cancel the contract if the lost part is so important that he would not bought the property without it. In this case, the buyer must return the remaining property in the same condition as when it was received. Article 1557 states that warranty against eviction cannot immediately be enforced. Before the buyer can demand remedies, there must first be a final judgment, declaring that the buyer lost the property and the decision can no longer be appealed. Only then can eviction be legally recognized. Article 1558 provides that the seller cannot be held liable for warranty against eviction unless the seller is formally summoned in the eviction at the request of the buyer. This means the buyer must officially include the seller in the case, so the seller will have the opportunity to defend the title or the ownership of the ownership sold to the buyer. Article 1559 requires the buyer when sued and facing possible eviction to ask the court within the property period to include the seller as a co-defendant in the case. Simply informing the seller is not enough because seller must officially become part of legal proceedings. This rules gives the seller the opportunity to defend the title and help protect the buyer's possession of the property. If the buyer properly includes the seller, the buyer may later enforce the warranty against eviction. Article 1560 protects the buyer when the property sold has a hidden or non-apparent burden or servitude that was not stated in the agreement. If the burden is serious enough that the buyer would not have purchased the property had he known about it, the buyer may rescind the contract or claim damages. However, these rights cannot be exercised if the burden is already recorded in the registry of property, unless the seller expressly guaranteed that the property was free from encumbrances. The law also provides that the actions for rescission or damages most generally be filed within 1 year. Subsection 2. Warranty against hidden defects of or encumbrances upon the thing sold. Article 1561 states that the seller is liable for hidden defects existing at the time of sale. A hidden defect is a flaw that is not visible and makes the item unfit for its intended use or greatly reduces its value. In such cases, the buyer may seek remedies from the seller. However, the seller is not liable for defects that are visible or defects that an expert buyer should have discovered because of his profession or knowledge about it. Article 1562 explains implied warranties in the sale of goods even if not written in the contract. The law automatically includes certain guarantees. If the buyer relies on the seller's skill or judgment for a specific purpose, the goods must be reasonably fit for that purpose. Also, goods sold by description must be of merchantable quality, meaning they must be safe, usable, and suitable for ordinary use. Article 1563 states when a buyer purchases a product using its patent or trade name, there is generally no implied warranty that it is fit for a special purpose because the buyer relied on his own choice rather than the seller's judgment. However, the seller may still be liable if there is an express guarantee or if the buyer relied on the seller's recommendation. Even without a warranty, for a special purpose. The implied warranty of merchantability still applies, meaning the product must still be safe.
Article 1564. An implied warranty or condition as to the quality or fitness for a particular purpose may be annexed by the usage of trade. This article means that an implied warranty may exist even if it's not written in the contract, based on common practices or usage of trade in certain industry. It reflects the intention of the parties and applies only to both are aware of, expected to be aware of such usage. And if there is no established usage of trade, then no implied warranty arises. For example, when buying rice from a supplier, it is expected that it's of good quality even if not stated. This applies in industries where business systems are commonly followed. Article 1564. In the contract of sale by sample, the seller is entitled to the most of the time. There's an implied warranty that the goods shall be free from any defect rendering them unmerchantable, which would not be applied on reasonable examination of the sample. This means that in a sale by sample, the buyer must receive goods that match the sample and are free from hidden defects. If the defect is not visible and the buyer relies on seller's skill or judgment, the goods must also be merchantable. The delivered goods will not correspond to the sample the buyer may receive. For example, if fabric is purchased based on a sample, the delivered fabric must match and must not contain hidden defects. This applies in biases and trade. Article 1566. Things have a potential substance may be the object of the contract of sale. This article allows the sale of future goods such as expected harvest or manufactured items. The parties must clearly intend to include such goods and their existence must be reasonably certain. If the thing does not come into existence, the sale is void. For example, a farmer may sell crops before harvest. This applies in agriculture and production transaction. 1567. In the cases of articles 1561, 1562, 1564, 1565, and lastly 1566, the vending may elect between drawing from the contract or demanding a proportionate reduction of the price with damages in either case. This article gives the buyer two alternative remedies: to rescind the contract or to demand a reduction of the price. These remedies cannot be used at the same time, and in either case, the buyer may claim damages. Loss is proven. For example, if a defective laptop is sold, the buyer may return or keep it and ask for a lower price. This applies when there is a breach of warranty. Article 1569. Effect of loss of the thing sold with hidden defect. Article 1569 explains that even if the thing sold is later lost due to a purchase event or even the fault of the buyer, the seller can still be held liable if there was already a hidden defect at the time of the sale. The buyer can recover the price paid, but the value of the thing at the time it was lost will be deducted. If the seller acted in bad faith, meaning he knew about the defect, he must also pay damages. For example, if someone buys a machine with a hidden defect and later breaks completely to use, the buyer can still recover part of the price even if the damage happened later. This applies in a situation where defects already existed before the sale. Article 1568. The thing sold should be lost in consequence of the hidden faults, and the vendor was aware of them. He shall bear the loss and shall be obliged to return the price and refund the expenses of the contract with damages. If he was not aware of them, he shall only return the price and interest thereon, and reimburse the expenses of the contract which the vendee might have paid. This article explains that the thing is lost due to hidden defects. The seller's liability depends on his knowledge. If he knew about the defect, he must return the price, refund expenses, and pay damages. If he did not know, he only returns the price with interest and expense. For example, if a defective car breaks down completely and the seller's liability depends on whether he knew about the defect, this applies when the defect causes total loss. Article 157, Application to Judicial Sales. This article applies the rules on hidden defects to judicial sales, such as foreclosure or court-ordered sales. However, in these cases, there is generally no warranty against eviction or hidden defects. This means that the buyer accepts the property as is with limited protection. For example, if you buy a foreclosed house, later discover defects, you usually cannot charge the seller liable. This applies in legal or court-supervised sales. Article 107, Description of Actions. This article provides a time limit that the buyer must file any action related to hidden defects within 6 months from the delivery of the sale. After the period, the right to file a case is authorized loss. For example, if a buyer discovers a defect but files a complaint after 6 months, the case will no longer prosper. This applies to all claims involving hidden defects under the earlier articles. Article 157, Inventory defecting animals sold together. This article talks about the sale of animals. If 2 or more animals are sold together, the defect of one does not affect the others. The buyer can engage in the sale of the defective animal. However, if it can be proven that the buyer would not have bought the other animals without the defective one, then the entire sale can be rescinded. For example, a farmer buys 3,000 and one is sold. He can only return the seed cow. But if he bought them as a pre-set and the seed one was essential, he may cancel the whole transaction. This applies to holding an animals.
Article 157 states that the rules on hidden defective animals also apply to other things. If several items are sold and some are defective, you can complain about those items only. For example, if you buy a set of appliances and one is defective, you can complain about that one item. Article 137 states that there is no warranty on animals from affairs, auctions, and order. The buyers are expected to accept that risk. For example, if you buy a cow and turns out to seed, you cannot demand a refund. In Article 1575 states that the seal is void if an animal has contagious disease or it is unfit for its purpose. For example, if you buy a sick chicken and infect others, the seal is void. Under Article 1576, a defect is considered inventory if it cannot be discovered even by an expert. However, if a veterinarian fails to detect or disclose that defect due to ignorance or bad faith, they can be held liable for damages. So, in Article 1577 states that the buyer must act within 40 days from delivery. For example, if you find defect in 20 days, you can still complain. Article 1578 states that the buyer is liable if the animal dies within 3 days due to an existing disease. For example, a pig died within 3 days because it was already Article 1579 says that the buyer must return the animals in good condition if the sale is cancelled. For example, if the buyer injures the animal, they are responsible. Article 1580 gives 2 options, which are cancel the sale or reduce the price. For example, you can return a horse or ask for the lowest price. Article 1581 states that a sale of large cattle must follow special law and proper document. For example, if you are selling a cow, it must be officially registered.